So what do we have here? The grand jury right. So the grand jury right. We have the grand jury from the Fifth Amendment. The Fifth Amendment says that you can't be accused of infamous or capital cases unless you've had a presentment or an indictment from the grand jury. The exceptions are if you're part of the military, you're part of the militia during a time of war or a time of danger. If you're part of the militia or the military during war or danger, then the grand jury right, that's a nullifying clause. But that's the only exception. So I want to talk about how far this grand jury right goes. This grand jury right goes back to the Magna Carta, King John's Magna Carta. That was 1215 and 1225. So the Magna Carta, when it came to Thames, when it came to some of these other cases, they had pointed out just a few things. They pointed out the Magna Carta. They pointed out to the state constitutions. So I want to do the same thing. The grand jury right goes back to the Magna Carta, and it goes back before the Magna Carta. King Henry II, the Assize of Clarendon, 1166, the Assize of Northampton. So you have King Henry II, the Assize of Clarendon was 1166, the Assize of Northampton, not Hampton, but it is kind of Hampton, Northampton, that sounds better, 1166. The Magna Carta of King John was 1255. So this goes not just back into American history, but this goes all the way back to English history. That's when they had the presentment. That's when they had a presenting jury. King Edward III was 1634. So when they've actually had the grand jury of when they would have, the whole idea of the grand jury is this. You get 12 to 23 of your countrymen come in, and then they say whether or not there was probable cause that a crime has occurred. So once you have 12 of the 12 to 23, then you have a grand jury indictment. So that has been around since King Edward III, 1634. The Assize of Clarendon was just the accusatory body. They didn't actually try the offenses. But with King Edward III, they would actually accuse the people of the crime and then also try it at the same time. The right to the grand jury indictment goes back to the Blackstone Commentary, 1769. So that's just right before the U.S. Constitution was written. The Grand Remonstrance. This is still back in England, but the Grand Remonstrance was presented to King Charles I. And what do we know about King Charles I? Well, he got beheaded, right? So King Charles I got beheaded, and the Grand Remonstrance had predated that, because the Grand Remonstrance was the Parliament saying, hey, King Charles I, what the hell is your problem? So the Grand Remonstrance of 1641 talked about the grand jury right. The grand jury right, you'd like to think that the Bill of Rights of the U.S. Constitution is actually good law, but apparently that's the case. Between Amendments 1 through 8, the Third Amendment, the Seventh Amendment, the Eighth Amendment's excessive bail, and then the first clause of the Fifth Amendment is not law. At least the Supreme Court hasn't, put a stamp of approval on the damn thing. So out of the 32 freedoms that's listed in the first 8 amendments, 4 of the freedoms haven't had a stamp of approval by the Supreme Court. Let's carry on. So in the English colonies, right? America is going to become America in 1776. In the English colonies, Massachusetts had the first grand jury, 1634. So that's how long the grand jury has been in America, since 1634. The Massachusetts Body of Liberties, the very first Bill of Rights in America, 1641, also talked about the grand jury. New York's 1787 Bill of Rights talked about the grand jury. Massachusetts' 1788 Ratifying Convention also talked about the grand jury. Patrick Henry says you should have had the hundreders. How come you didn't put any of the hundreders in there? You didn't legalize the common law. Patrick Henry said that 1788 at the Virginia Constitution Ratifying Convention. 1789, Madison is going to introduce 20 amendments, which ultimately would become the Bill of Rights, the 10 Bill of Rights. 1789, Madison talked about the grand jury. We have an American right to a grand jury indictment. We have an American right. It comes from the Fifth Amendment. Our grand jury right comes from the Fifth Amendment. So if we're going to ignore what the First Amendment, Second Amendment, Third Amendment, Fourth, Fifth, Sixth, these are a lot of amendments. You would like to think that there's actually freedoms in the body of the Constitution. You have a right to habeas corpus. You have freedom from bills of attainder, freedom from ex post facto laws. So those were rights inside the body of the Constitution. And then you also have the women's right to vote, and then other, no poll taxes and other freedoms that are past the Bill of Rights. But at the very least, can we say that the Bill of Rights is law? Why can't we say the Bill of Rights in America is law? When it comes to common law, is the U.S. Constitution not common law? Is that not a law that's supposed to be common to us all? Of course it is. The Constitution isn't just a common law to us all, but it's the supreme and paramount law for us all. John Peter Zenger, there was a famous case called John Peter Zenger, 1735. And this again is, before America. So this is when America was a bunch of colonies, but we've had the grand jury right, not just back in England, from all the way, 1166, we've had the grand jury from 1166, and every century past then, up until the 1600s when the colonization of America started, to begin. And so the grand jury has been with America since we started colonizing the damn place. 1634, you had Jamestown, 1607, 1619 was, the 1619 project, or when they started, incorporating slaves. So this was 1607, 1619, 1634, Massachusetts had a grand jury. John Peter Zenger, there was 2 grand juries that refused to indict John Peter Zenger. John Peter Zenger should actually be like the core of American common law. And, I can't stand that old ancient English common law, but John Peter Zenger, his entire case was he was a journalist who had criticized the governor. So this journalist, John Peter Zenger, had criticized the governor, the royal governor, and he's sitting there, typing a bunch of stuff in his newspapers, and 2 grand juries did not indict him. 2 of his peers would not indict him. And so then the damn, royalist went ahead and proceeded by information alone. The problem with information alone versus a grand jury is the difference between tyranny and freedom. Blackstone explains it very well. And then the Constitution, the ratifying convention of Nevada explained it very well too. So Blackstone says this: in England, you cannot be convicted of a infamous or capital crime, i.e. felony, if you look at U.S. Green v. U.S. and Mackin v. U.S. 1958-1886, unless you have a grand jury indictment. So John Peter Zenger, they're going to press, by information only. They're going to press on by information only. Blackstone says this: if you are accused of a felony, you can't be convicted until you get at least 12 people from the grand jury to indict you. And an indictment is, kind of nothing, but it just says that there's probable cause that a crime may have occurred. Plus 12 people from the petite jury. So you get 12 people from the grand jury, 12 people from the petite jury, which is your ordinary jury where, you have the trial and then it has to be a unanimous decision. Once you get 12 people from the grand jury to accuse you and then 12 people from the petite jury to convict you, then that's a good, solid conviction. That's much better than just some asshole type some crap into the computer. That's tyranny. Anybody could just type some crap into the computer, right? Oh, I saw JoJo Beans. He was pooping out in the damn street. Is that true? Is it not true? If you're just one person and you just type that into the computer, there's some places in America that says, oh, that's good enough. Yeah, we'll go ahead and hit him with a felony saying that he's, this great pooper of whatever, Ellsbury. So Blackstone explains the grand jury right very, succinctly. You need 12 plus 12. You need 24 of your countrymen to say that you had committed the felony before that the conviction could go forward. In Nevada, he basically said the exact same thing. You had this debate, you had the Civil War was going on, Nevada came up, Nevada was going to become a state, right? It's the battle-born state. Why was it the battle-born state? Because it was born during the Civil War. They were talking about the grand jury, and then they said, well, it's, adopted the exact same language from the U.S. Constitution. Somebody said, we don't want to do that. We just want to go ahead and, by information only. Information, right? Quote, unquote. So just by some thought, some idea that some asshole typed down or write down on a piece of paper, that's what one guy had said. And then the other guy, I forget their names, but the other guy in the Nevada 1864 ratifying convention, he said that there's problems with both. There's problems with both. A prosecutor, it's kind of the grand jury is a prosecutor's amusement park. And so is the preliminary hearing. You're supposed to look at the preliminary hearing in the light, best towards the prosecution. So actually, it makes no sense for the prosecution to forego a grand jury, and then some of them want to do a preliminary hearing instead of doing the grand jury. Both of those hearings are weighted towards the prosecution, so it makes no sense for the prosecution to ignore either one. Now, according to the guy in the Nevada Constitution, the ratifying Constitution, he had said a very fascinating thing. The guy, he said that the grand jury could be wrought with a bunch of problems. You could actually have 12 people that are friends of the prosecution. There's the saying that you can indict a ham sandwich. You could have tyranny. You could have corruption. You could have something bad that happens with the grand jury system. That's totally possible. But he says if I had the choice between allowing 24 of my country members to convict me versus just one asshole behind closed doors typing some shit in to the computer or to type or to write it up, just having one person, the prosecutor, just type whatever crap up that they want to, there's more problems with that system than there is with the grand jury system. The grand jury is 12 plus 12. 12 people from the grand jury indict you, 12 people from the petite jury convict you. That's the Fifth Amendment. That's the Fifth Amendment. And if we can't even agree on the damn Bill of Rights, do we even have constitutional law in America? Furthermore, when it comes to 1871, 1868, when they passed the 14th Amendment, well, how many state constitutions protected the grand jury right? In 1868, you had a lot of state constitutions that protected the grand jury right. 34 out of 37. When it came to the Second Amendment, you only had like 21 out of 37. So there was more state constitutions in 1868 when the 14th Amendment was passed, because that's, you got to go through the Fourth Amendment, right? In order to get the Fifth Amendment right, you got to go to the Fourth Amendment, then you got to circle back around. 21 out of 37 of the state constitutions that protected the Second Amendment. And then Heller's going to get passed, and McDonald's going to get passed, and then that's going to get incorporated to the states. So there was more state constitutions that protected the grand jury right than protected the Second Amendment right in 1868 when the 14th Amendment was passed. 34 of 37. That's remarkable. 34 American states out of 37. You had 37 states in 1868, and 34 of them protected the grand jury right. And then today, 48 states out of 50 have a grand jury right. Some of them allow it just for some things and not for others, and then 2 states don't have it at all. But out of all 50 states, 48 states in the state constitutions protect the grand jury right. So if we're looking at constitutions, is it the federal constitution? Is it the state constitution? Well, let's just put them both together, right? The U.S. Constitution says you got a grand jury right. 48 out of 50 states say you have a grand jury right as well. And then some states, like Colorado, specifically says for a felony, you got to have a grand jury. So the Fifth Amendment of the U.S. Constitution has some, clumsy language. It says infamous or capital. If you are accused of an infamous crime or a capital crime, then you get a grand jury right. Well, what does that mean? What does infamous mean? What does capital mean? Capital means, put to death. Infamous could be, they're going to take a limb from you. In the common law, they would cut off your damn foot. But according to those 2 cases, Green v. U.S. and Mackin v. U.S., 1958, 1886, is a little complicated and a little, windy. But ultimately, they were saying that anything that's over a year, that gets you the penitentiary. If you go to the prison system of the federal laws, anything that you could get 1 year of punishment or above, then you're guaranteed a grand jury indictment. And what kind of charges will get you 1 year of prison time in the federal government? Felonies. And so, therefore, those two cases, Green versus U.S. and Mackin v. U.S., 1886 and 1958, have interpreted the Fifth Amendment requirement for a grand jury of infamous or capital to mean felony. But Colorado specifically says felony. So if you're like, wait a second, what's this capital and infamous mean? But then you live in Colorado. If you read Colorado's Constitution, it's Article 2. The Bill of Rights is Article 2. And I forget the exact, there's 23, there's 2 grand jury articles in Colorado's Bill of Rights, but it specifically says felony. Let me actually get it because I think this is important. So Colorado, the Bill of Rights, I mean, it's only a couple pages. It's kind of incredible that we all don't just immediately put our freedoms together, because what freedoms do you have? Well, you got the freedoms that the U.S. Constitution gives you, and then you got the freedoms that the state constitutions give you. And then it's even more important if you think about the right to everything. The whole idea of having civil liberties is you get these little tiny freedoms because you want people to buy into the society because you're born with the right to everything. But then Hobbes says if you're born with the right to everything, he, she, them, they, everybody's born with the right to everything, eventually it'll be a war of all against all. So we want civil society. We want to have civil liberties so that way people give up their right to everything in order for these, kind of tiny little freedoms. Your right to the Second Amendment, right to the speak, and the right to petition. Section 8. Okay, so Article 2, Section 8 of Colorado's Constitution says, prosecutions, indictment, or information. Until otherwise provided by law, no person shall, for a felony, be proceeded against criminally otherwise by indictment, except in cases arising in the land or naval forces or in the militia when in actual service in time of war, public danger, and then in all other cases, offenses shall be prosecuted criminally by indictment or information. So specifically, Section 8 of Colorado's Constitution says a felony. You get a grand jury right if you're accused of a felony. So you don't even need, Mackin and Green to interpret the Fifth Amendment for you if you're in Colorado. In 1791, 4 states had protected the grand jury. 1800, 7 states protected the grand jury. 14th Amendment's going to get passed in 1868. 1983, the civil rights cases, the Civil Rights Act is going to get passed in 1871. So 1868, 1871, 34 of 37. That's remarkable. That's like every goddamn state. Every fucking state but 3. When the 14th Amendment was passed, every state but 3, 34 of 37, had said that it was good, that you have a grand jury right. And then today, 48 of 50. 48 of 50. There's only 2 states. I don't even know which 2 states don't do it, but what the hell is their problem, huh? U.S. v. Nixon, 1974, says that the public has a right to every man's evidence. That comes from the grand jury context. Scalia actually said that the grand jury is so untouchable, so unassailable, that the 3 branches can't do shit with the grand jury. Because the grand jury could, issue an indictment. An indictment is when a prosecutor calls up the witnesses and then gets the grand jury to do the indictment. It's more formalized, it's more professional, it's got a more professional feel to the damn thing. But technically, when you have a grand jury and it's been convened, the grand jury can issue any indictments that they want to. And that's called a presentment. So a presentment is just a jury accusation. The grand jury gets together, you have 23 grand jurors, the prosecutor says, hey, this person right here is guilty of, A, B, C, and D. And the grand jury says, no, that's not true. We think that, this person and that person is guilty of A, B, C, and D. And then the grand jury can override the prosecution, the prosecutor, and the indictment, and then issue a presentment. So that's remarkable. Scalia said that the grand jury is essentially above the 3 branches of government. When the grand jury is accusing somebody of a major crime, there's nothing that the 3 branches of government can even do. Stanford v. Kentucky, 1989, says that the primary and most reliable indication of a national consensus is the pattern of enacted laws. So when it came to the incorporation of the Second Amendment with McDonald and the incorporation of the excessive fines provision of the 18th Amendment, they did a big, extensive historical, inquiry. It was just, they said it had to be rooted in tradition, and it had to be rooted in history, and then it had to be fundamental. It had to be a fundamental right that is implicit in the concept of ordered liberty, some crazy shit like this. But ultimately, the way I understand anything is, if you're an American and you sit at home and you read the Bill of Rights, then that Bill of Rights is good. You're at home and you read the Bill of Rights and it says that a soldier cannot quarter inside your home unless you give them permission, then that means a soldier can't quarter in your home until you give them permission. The only way that you could override an amendment is with another amendment. The 18th Amendment was prohibition. The 21st Amendment overrode prohibition. So you had to pass another amendment to overturn a different amendment. The only way that you can overturn an amendment is either by an amendment or with the Constitutional Convention, a brand spanking new Constitution. Last but not least, let's talk about Hurtado. Okay, so Hurtado v. California. We're not going to have the incorporation of our freedoms. That's not going to happen until 1925. That's Gitlow v. New York. So 1925, Gitlow v. New York is when they had incorporated the freedoms. The guy's going to lose the case, but they said, well, of course, the Bill of Rights, at least Amendments 1 through 8, Amendment 9 and 10 are kind of a different species. They're a little bit different. But Amendments 1 through 8 apply to the states. 1925. Gitlow's going to lose that case, but he's going to set a standard of incorporating our rights. And then since 1925, just slowly but surely, they've been incorporating, the First Amendment, Second Amendment, not the Third Amendment yet, but the Fourth Amendment, Fifth Amendment, most of the Fifth Amendment, Sixth Amendment, Seventh Amendment. But that was in 1925. Before 1925, you had Hurtado. And Hurtado v. California, this is 1886, I want to say. Now, Hurtado specifically says, no, you don't get a grand jury right. You don't get a grand jury right. But in lieu of a grand jury, you got to at least hold a preliminary hearing. So if you hold a preliminary hearing, which has to be, there's 4 points. There's 4 points of a preliminary hearing. You got to hold the preliminary hearing in the presence of the accused. The accused is entitled to a lawyer. The accused is entitled to cross-examine the witness who was procured by the prosecution, and then the witness's statements has to be reduced to writing. And then 4, the magistrate or the judge has to issue a probable cause certificate, which is akin to the grand jury indictment. So if you're going to have a preliminary hearing, it's got to rise to the level of a grand jury indictment. You're going to sit there and say, I don't really want to go out there and get 23 of these American assholes and then convince 12 of them. If anything, that'd be a good check on yourself. If you're a prosecutor and you're like, yeah, that's a crime, and then you just start, scribbling a bunch of felonies against a bunch of other people, how do you know it's actually a crime that your fellow countrymen and your peers would agree with? If you're a prosecutor and you think something is a crime, then you have the evidence, you have, the law backing you, the evidence and the witnesses, and you should be able to get at least 12 people out of 20. That's not even a majority. 12 out of 23, that's not even a majority. So if you're a prosecutor and you think somebody committed a felony, it should be easy as hell to get 12 out of 23 people in the grand jury to listen to you, to believe you, and then to issue the damned indictment. But the grand jury and the preliminary hearing is weighted towards the prosecution. So it makes no sense for a prosecution to forego both the grand jury and the preliminary hearing. They forego the preliminary hearing, they forego the grand jury indictment, then due process is out of the window. The grand jury right is both a procedural and substantive right. And so therefore, if they try to take away the grand jury right from you, you got to use strict scrutiny. What's the government interest in taking away your grand jury right? What's the government interest in taking your First, Second, Third, Fourth Amendment away? Sometimes you have just rational review, so it's just, we thought it was reasonable to just go ahead and take his rights away from him. But strict scrutiny says when it comes to the fundamental rights and fundamental freedoms, you can't just use a rational basis. You got to use not intermediate scrutiny, but you got to use strict scrutiny. You got to be strict. So why would you take away somebody's grand jury right? Well, if they're in the military, during a time of war, then that's actually, right there in the damn amendment. That's a nullifying clause that's actually within the amendment. That'd be one reason to not give somebody a grand jury right. So if you're to point to Hurtado, I'm actually giving, the other side, basically, this is what I would argue, if I was on the other side's team. But even with their argument, even if you give them Hurtado v. California, well, Hurtado v. California says you don't have to have a grand jury. There, I won. I won Hurtado v. California. That's all I got to say. Well, no, that's not the case, because you got to have a preliminary hearing, a robust preliminary hearing. If you didn't have a preliminary hearing, you didn't have a grand jury right, then you broke the fucking U.S. Constitution. And probably your state constitution too, since, 95% of all the state constitutions protect the right to a grand jury. Colorado specifically has Rule 7 of Colorado's criminal procedure, and then CRS 165206 and CRS 165301. There's some exceptions, but essentially, you're accused of a felony, you get a grand jury hearing. They can't proceed without a grand jury indictment, or in lieu of a grand jury indictment, they give you a preliminary hearing. They don't give you a grand jury indictment, they don't give you a preliminary hearing. Well, then they're damned. Then they're fucked. Then they're fucking fucked. They didn't do the shit right. They didn't do what they should have done. Now, if you're a tyrant, any excuse will serve a tyrant. That comes from Aesop's fable. You had a wolf and a lamb. A wolf and a lamb was at a river, and the lamb was, just drinking a little drink down the creek a ways, and the wolf was like, "Hey, lamb, I know you. You're the one that was talking all that shit about me." And the lamb was like, "No, sir, you're mistaken. I was just drinking the water. I don't even know who you are. I've never talked to you." "Oh, okay." Then the wolf says, "Wait a second, lamb. It was your parents. Your family was talking a bunch of shit about me." And the little lamb is like, "No, sir, I come from over there. We've never seen you. We've never talked to you. You are mistaken. That's not the case at all. That, I don't understand what you're saying." And then the wolf says, "It doesn't matter. You're a little lamb, and I'm just going to eat you up anyways." Any excuse serves a tyrant. If a person can be a tyrant, then they can also, perjure themselves in order to sustain their tyranny. Injustice anywhere is a threat to justice everywhere. Resistance to tyranny is obedience to God. Resistance to tyranny is obedience to God. So I just want to point out that we've had a long history and tradition. And then last but not least, oh my God, this is the best thing. In 2023, you have the president, right now. In 2023, he had 4 grand jury indictments. If you want to try to say, we don't do grand jury nowadays. No, we've done grand juries since 1166, 1200s, 1300s, 1400s, 1500s, 1600s were colonized in America. English brought that shit over to America. So 1600s, 1700s, 1800s, 1900s, 2000s, 2023, Donald Trump had 4 grand jury indictments. And the grand jury is both a sword and a shield. So because they had to go through the grand jury indictment, he eventually is going to be able to beat the charges. But if you're wealthy and rich and you got, plenty of lawyers to say, "Hey, make sure you get my grand jury indictment," doesn't matter. It doesn't matter what you think of, the cases or what you think of him. He got a grand jury indictment. So the grand jury was being utilized 2 years ago in these high-profile cases. So even in the 2000s, 2010s, 2020s, the grand jury has been with America since the very beginning. It's in our blood. It runs deep in our history and in our tradition. And more importantly, it's in our laws. It's the Fifth Amendment. It's the Fifth Amendment to the U.S. Constitution. So, do I have anything else to say? Anybody got any questions? If you're an American, then you should be happy with your rights and your freedoms. I did hear an anarchist or a communist once say, "Man, I would hate to be a constitutionalist." So, yeah, I guess I can kind of understand that, but not really. As an American, then you should be happy when somebody enforces your freedoms, because if other people have a right to speak and peacefully assemble, and a right to bear arms, and a right to kick out soldiers quartering in your homes, and the right to a warrant, and a right to a grand jury indictment, then we all have a right to a grand jury indictment. So I'm not just fighting for myself. I'm fighting for all Americans' right to a grand jury indictment. You can't be accused of a felony until they indict you with a grand jury. You're welcome, America. You are welcome.